Hello everyone, I'm Arnie Clarke. I'm a UK and European patent attorney and partner at Gill Jennings Every, a specialist IP firm based in London and Munich. Welcome back to part 3 of our introductory talk to oppositions at the EPO. So as an opponent, what can you do to help? So technical data is one thing that I think is absolutely essential to attacking a case. As I mentioned earlier, about 52% of cases go down on inventive step. Anything you can do to support that has got to be good. So if you have some data that can show that an invention doesn't work, or actually more often, that it at least doesn't work across the scope of the claim, so the technical effect that's being relied on can't be achieved across the scope of the claim, that is absolute gold from an opponent's perspective. Now, what do I mean by attacking the scope of the claim? Well, the analogy I might use would be you have a patent that, for example, has the example of a Ferrari in it, and the technical effect is a 200-mile-an-hour vehicle. That's what they're going to rely on. But the claims don't reflect that. The claims have just got conventional vehicle parts in there. Now, what you need to show is that you can't achieve a 200-mile-an-hour vehicle with all conventional vehicle parts. And what you might need to do is build your Reliant Robin and demonstrate that it never gets over 60, but that it falls otherwise within the scope of the claims. That is going to help you reduce the scope of the claims, and again, give you an opportunity to start eating away at the monopoly that the patentee has. Often the patentee may have no answer to that. As soon as you start to erode the scope of the claim, the whole thing falls over at that point. So I'd say absolutely be prepared to both budget in terms of monetarily and time to be able to support your patent attorney with some technical data that could help with the inventive step attack. And expert evidence, I said earlier, the EPO doesn't really like expert evidence to a certain extent. Actually, it's helped me immensely in 50-50 cases. If you need to get something over the line and it's a close one, then absolutely consider expert evidence. Just don't throw it at every single case that you're going to be involved in. What else can you do to help? Well, there is better searching for sure. I often have clients turn up with searches that have been carried out by academics, by in-house technical people. I would suggest that's fine. Sometimes they're very good. Sometimes you will know about stuff that a professional searcher won't, but professional searchers, in my experience, really do find things that other people will not find. So consider engaging a professional searcher, or we can obviously help with that side of things. We know people who will carry out that sort of service. Search within the convention year, absolutely. Often patentees are so happy with what they've done, they publish the essentially what they've just filed a patent application on, and then they lose priority, and then that disclosure becomes prior art against their final application. Those of you who are following things like the CRISPR case, the Broad Institute case, a hugely important case at the EPO recently, exactly that happened, and they invalidated their patent based on their own disclosure made during the priority year. So search for those intermediate disclosures wherever you can. Use Wayback wherever possible. You'd be amazed what people put on their websites and then realize and remove at some later date. Go and have a look at the websites of the companies that you're opposing, see what they put on there that might be helpful. Search inventive step, that's pretty critical as well. I'd say don't just look for novelty destroying disclosures, focus on best combination of references. Often anything that's vaguely novelty destroying will have been found. Look for things that actually go to the inventive step arguments. And also look to common general knowledge as well. The EPO is often not very good at finding, they're brilliant at finding patent documents and often journal references, not so good at identifying textbooks, desk references, trade journals, reviews, those sorts of things that establish common general knowledge. That can frame your inventive step arguments a lot better. So I always try to look to those to support my case wherever I can, and searching of those is crucial. So we're coming to the end. Just as a summary, I'd say try and align your opposition strategy with business strategy, business plan, and make sure that you review that constantly throughout opposition. Remember, the opposition lasts 16 months, call it 18 months, and with appeal beyond that as well. A lot can change in that time. Keep going back and working out whether you still need to be spending money on your opposition, or whether you need to be spending more money on your opposition to get what you want. Of course, as I said before, it's cheap and easy to get out of the opposition if you don't want to proceed with it any further. So, bear that in mind. Set your clear desired outcomes and keep measuring that against how your case is progressing. And budget appropriately. I don't just mean in terms of money, I mean in terms of time. You might be asked to carry out comparative testing. You might be asked to be an expert. If you're in-house technical person, you might be the expert that would support this case. So it might be your time which is essential for this, not just the money to support the case. And on that note, be prepared to get involved. I think work with your patent attorney to come up with the best strategy and really clearly lay that out as to what you want to achieve, and then hopefully trust your patent attorney to deliver that. Thanks, everyone. That concludes our talk today. I hope you found it a helpful introduction to EPO oppositions. If you want any further reading about our oppositions team at Gill Jennings and Every, you can have a look on our website, which is www.gje.com. Also, do feel free to get in touch directly via email or connect on LinkedIn. Thanks very much for joining. Bye.